Markets developed significantly in Europe in the later medieval period, and England was no exception. Yet there were two things that set England apart from many of its continental neighbours. First, its common law system, created in the 12th century by Henry II, and secondly, its well-developed and centralised governmental structure. Both of these had implications for how markets developed in England, and importantly, the revenue and benefits the government could derive from them. Before I turn to markets, I want to say a little more about both the common law and late medieval English government. Those of you who know me know I've been slightly obsessed for the last 10 years in talking about the growth of the English state, so I hope you'll forgive me the deviation. The common law came into existence as a pragmatic response to a particular set of challenges. When Henry II acceded to the throne in 1154, he immediately sought to restore order after a period of civil war during the reign of King Stephen. In doing so, he needed structures that would enable the government to address what was by then a very large number of ongoing disputes, and that would continue to function in the king's absence and deliver money. The latter, both functioning in the king's absence and delivering money, was crucial because Henry had large inheritances in France, large numbers of lands in France, which he had to defend against the ambitions of the Capetian kings. And that meant that he could spend only a minority of his time in England, and of course, war costs a lot of money. For the king's subjects, on the other hand, the common law actually proved immediately very popular. Not only was it cheap, relatively quick and easy to use, it was broad in scope. It offered remedies for a wide and ever-growing range of property disputes, from contested seizures to inheritance challenges to questions of fundamental right. And from the outset, the types of legal writs available expanded rapidly. With law courts based in London, as well as itinerant justices who crisscrossed England, quite literally, it was a remarkable system. But this unique iterative legal system that spanned the whole of England was only one aspect of English royal government. By the late Middle Ages, England had been subject to centralised royal government for a long time. And its structures continued to grow in number and sophistication during this period, both centrally and locally, routine and ad hoc. The expansion of government was not, though, simply about ambitious kings and increased royal power. From the start, the king's subjects were co-opted into running government, and they quickly demanded their say. In 1215, the barons established through Magna Carta that the king must consult with his subjects when he wanted money, a move they made in response to the fact that the Angevin kings had arbitrarily extracted huge sums of money from their English subjects to pursue their own dynastic ambitions on the continent. In thus placing the king beneath the same law as his subjects, they made it impossible for him to extract revenue against their will without generating political crisis. This in turn begot Parliament as a forum in which royal requests for taxation were presented and considered. Over the same period, foreign policy became less about the king's dynasty than about the English crown and its rights, and at the same time a sense of English identity was developing. These developments enabled some of England's greatest military victories under Edward III. By the late 14th century, Parliament, with its two houses, the Lords and Commons, was a dynamic forum for discussion of foreign policy and the adjudication of matters of national taxation, with representation that even included peasants and townsmen. What all this meant was that under strong and able kings, and to some extent even in their absence, the governmental structures of late medieval England played a role in opening up some markets, permitted government oversight, and provided protection for those involved in markets of varying sorts. I want to explore three aspects of this. The first is in relation to commerce, domestic and international. Although some customary rules for trading across borders had been developed by merchants, there was no fully fledged or standardised set of international mercantile laws in this period. The most significant protections and regulations for commercial traders in England and on the continent of Europe came instead from kings or great lords. Of course, it was in the king or lord's interests financially for trade to flourish, since he derived income from it in the form of taxes and duties. Medieval English kings regarded themselves as the ultimate regulators of markets and protectors of merchants, whether that be from robbery or from unfair practices. And successive late medieval rulers set about providing a framework through the common law to enable trading disputes to be settled without resulting in violence. King Henry III, who ruled from 1216 to 1272, is notable for his personal concern to protect merchants. After a particularly serious robbery of a foreign merchant on the Alton Pass in Hampshire, the king was beside himself with anger at what he saw as a cover-up by the local community. No suspects had been produced. Henry made it his business to address the matter in person. Now, we can see why this sort of thing would have been an absolute priority for the king. Not only was it the case that his authority depended on being able to uphold order within his realm, but actually merchants needed to be able to move and trade freely. The benefits to the king financially were extreme. Henry III was also the person who granted a royal charter to enable the Hanseatic League, for example, to trade in England. Yet, while common law courts adjudicated domestic merchant disputes, there was also some recognition, and this speaks to a little bit of what David Abalafi was saying earlier, some recognition of the extent to which foreign merchants needed to resolve commercial disputes between themselves while they were in England. In 1285, Edward I ordered the London sheriffs to establish daily courts composed of foreign merchants to facilitate that sort of settlement of disputes between them. Unsurprisingly, the importance of trade was recognised more widely among the king's subjects too. The baronial rebels who produced Magna Carta wrote in the charter on the king's behalf guarantees of safe and secure exit and entry for merchants. As in many other territories then, there were concerted efforts to protect trade and merchants, domestic and international, by the king and his subjects. There doesn't seem to be any evidence that there was a higher level of commerce in England than elsewhere. Geographical location and many other factors, some of which you've already heard about, may have been more important here. But England's common law and centralised governmental system did facilitate the provision of an environment in which trade could flourish, and importantly, royal revenues from commercial exchange could be secured. The second market I want to explore is the labour market, and in particular what happened to it after the Black Death of 1348-9. This new and devastating pandemic, think COVID-19, wiped out perhaps as much as 50% of the English population, think COVID-19 with no vaccines. As it did in Europe too, causing the balance of power within the labour market to shift rapidly from employers to employees. Where previously wages had been suppressed by a huge oversupply of labour, the loss of so many people in such a short period of time threatened to create uncontrollable upward pressure. If reduced demand simultaneously led to plummeting prices, the whole commercial trading system in England could be undermined and employers bankrupted. Government action was swift and preemptive, with Edward III fearing chaos and possibly civil disorder. Through the Ordinance and then the Statute of Laborers of 1349-50, wages were regulated, with the statute stating that the old wages shall be given and no more. And no one was permitted to remain, quote, idle. This intervention in the labour market was a wholly new departure for government. Mark Bailey, my colleague at the University of East Anglia, summarises, the Ordinance and Statute of Labourers represented a major and unprecedented intrusion in the English labour market. This legislation represents the first use of public policy to shape private legal obligations in the sphere of employment. The scale and ambition of this intervention and the persistence of English legislation were exceptional by contemporary European standards. Did the government's intervention work? Well, as it happened, the economic aftershocks of the pandemic and its subsequent waves played out somewhat differently from expectations, and prices remained buoyant for decades, facilitating large-scale evasion of the legislation. This was helpful in terms of civil order because there was a great deal of debate about how far government should be involved in regulating people's lives. Where the legislation was influential was in enabling a general tightening of the contractual terms between employer and employee, shifting the contractual balance of power, at least, in favour of the employer. When the economic crash finally came in the 1370s and there was little choice on the part of employers but to enforce the legislation more fully, it created massive social tensions, which were a crucial backdrop to the Peasants' Revolt of 1381, England's first large-scale peasant rising. Rebel peasants marched on London, killing the Chancellor and the Treasurer, putting heads on spikes above the Thames. I'm sorry, Kwasi. This is true. Targeting employers whose practices were regarded as the most egregious, many of whom were churchmen, and threatening to, quote, kill all the lawyers. Debate would continue, and of course continues today, about the extent to which government should regulate the labour market in these ways. But government regulation of the labour market would nonetheless remain a feature of English life thereafter. In fact, the fundamental tenets of the labour legislation promulgated in the 14th century prevailed until the 19th century. Thirdly and finally, I want to explore the landed property market. Henry II's common law had a significant influence here. It replaced the concept of seisin, that was of possession, with that of property, which gradually had the effect of weakening the feudal ties on which the possession of property had been formally based. This certainly enabled those below the level of tenant-in-chief to transfer property more easily, and probably contributed to the existing market in freehold land, with the common law meaning that title to property could now be defended in the royal courts. After Magna Carta, things became significantly easier for the king's tenants-in-chief too, as it meant the king was subsequently constrained in the disciplinary measures he could exert over them. That said, the market was limited by the fact that there were simply very few whole manors available. They were in the hands of a very small group of people. Where smaller pieces of land were concerned, until the early 14th century, there was an active market, as people competed for scarce land. Colleagues at the University of Reading who've conducted the latest research have shown that in the early 14th century, such small parcels of land tended to be more available at times of subsistence crisis, when sales of low-value land, probably by those in financial difficulty, took place in higher volumes. This is consonant with the idea that the landed property market was probably dominated by the lower classes at this point. After the Black Death, however, sales of high-value land surged, so things really began to change. The cataclysmic crisis opened up new opportunities for property ownership to more groups in society, particularly those from mercantile or professional backgrounds who sought social advancement. The surge in purchases during this period included those made for investment purchases, a segment of the market dominated in the first instance by wealthy London merchants who invested heavily in the counties around London. Although this pattern was not sustained in subsequent decades, the Reading Group suggests that the decline in population, together with increasing social and geographic mobility, opened up the market more generally to new commercial interests. The common law did not directly bring about the latter development, but it did provide a framework and legal protections within which speculation could take place, which readily facilitated this change in behaviour. To conclude, England in the later Middle Ages became increasingly commercialised, and a variety of markets, it's very convenient, and a variety of markets evolved, mirroring many realms and territories elsewhere. The fact that England had such a well-developed governmental and legal structure meant that there was an essential framework for commercial development to take place, and the necessary protections to go with it, particularly via the nationally embraced common law. What this did was make possible, under the most able and engaged rulers, a number of innovations in which England diverged from its continental counterparts, of which the labour legislation in the second half of the 14th century is the best example. Importantly, England's highly centralised governmental system meant that the king was ideally placed to benefit from any commercial growth that took place. And indeed, his access to extensive customs and tax revenues enabled England, and this comes back to the war point earlier, though it's a slightly different point from the ones that were being made. This enabled England to punch significantly above its weight in foreign policy terms in the Plantagenet period. It is perhaps no accident that England's most talented kings of the period were able to effect some of the greatest military victories in England's history. Think about Edward III and Henry V, later at Agincourt, and bring England to a preeminence on the European stage that would not be emulated for a long time. Thank you.
Thank you very much, Caroline. When I hear the expression common law, my thoughts go to case law, the organic growth of a body of legislation, so to say. But you stressed the importance of kings, Henry II not least. Can you elaborate a little on that relationship?
Yes, absolutely. So the common law was introduced by the king. And right from the outset, it was a very responsive system. So what people were coming to Henry II with was a whole array of disputes that they wanted the king to settle. Okay. So he starts to create writs that specifically address the sorts of things that they were coming with. So somebody's taken away your manor, so you bring a writ of novel seisin, literally new dispossession. Henry creates that writ. And so over time, what happens is the king, it's in the king's interest because he's going to be able to provide order to the realm, and also, of course, this brings money in as well. But at the same time, the subjects are coming forward and saying, well, we like this, we'd like some more of these. And so essentially this whole body of law emerges iteratively as people request more and more writs. And of course, as cases play out, you end up with precedent being created by the way in which judges have dealt with those particular cases.
All right.
So it's always a symbiotic system.
I see. Well, thank you very much.